Good morning, everybody. This project is called The Supreme Assimilation of Patent Law, and it explores a descriptive theory of recent Supreme Court patent jurisprudence. It argues the court has consistently sought to assimilate patent doctrine to broader legal norms and stamped out patent exceptionalism. It further argues that this project is both substantive and rhetorical, so sometimes the Supreme Court uses the language of assimilation to actually articulate brand new doctrine. Going a bit further, this project looks at this development to examine the broader tension between universality and exceptionalism in law. And I'll explain what those terms mean. All right, so the piece first delves into the value of legal universalism, by which I mean the consistent application of a limited set of rules across multiple subject matter domains. So First Amendment disputes, tax disputes, environmental disputes are all very different, but there's some intuition that we should have the same kind of rules of jurisdiction, procedure, and remedies that apply to all of them, right? So that's what I mean by universalism. And this value of universalism has a long history in the law. So the piece first focuses on formalism and Langdellian legal science, so associated with Christopher Columbus Langdell, former dean of Harvard Law School, who argued that the number of fundamental legal doctrines is much less than is commonly supposed, right? So we have an integrated system in law, a limited number of rules that apply to lots of different subject matter domains. We see something similar in the realist movement. Oliver Wendell Holmes once observed that the aim of legal thought was to render the teachings of centuries of reports, treatises, and statutes in the United States and England more precise and to generalize them into a thoroughly connected system. Again, a very integrated, holistic view of law. And we see universalism in other aspects of law as well, including various progressive movements, the federal rules of civil procedure, right? We have a single kind of uniform approach to all civil litigation, and the Administrative Procedure Act, which aimed to achieve relative uniformity in the administrative machinery of the federal government. Right, so there's this kind of fundamental intuition that we want a limited set of rules that apply to lots of different subject matter domains. This is in tension with kind of particularity or exceptionalism, this notion that we should tailor individual areas of law to individual subject matter fields. All right, so the piece then delves into the Supreme Court's recent forays into patent law. And as many of us have observed, after a long period of relative neglect, the Supreme Court has been quite aggressive in patent affairs, so granting certain a lot more cases, exercising its appellate jurisdiction over the federal circuit. And this development has engendered a number of different explanatory interpretive theories, right? So what really is going on here? And so among them, some have said the Supreme Court is reining in patent rights that have become too expansive under federal circuit jurisprudence, right? So there's conception that the federal circuit is very pro-patent. The Supreme Court has kind of curbed patent rights. I think we see this in the Doctrine. In addition, I think there's been a consistent effort to replace formalistic rules with holistic standards. So the Federal Circuit generally likes bright-line rules. The Supreme Court has consistently established holistic standards. This piece explores another descriptive theory of Supreme Court patent jurisprudence under the name the Supreme Assimilation of Patent Law. And it argues that the court has been eliminating patent exceptionalism and conforming patent doctrine to general norms and standards. Now this builds on prior scholarship, but I think this is the first comprehensive account of assimilation across multiple subject matter domains. And I think it's important to also point out rhetorical indications of assimilation. So as I alluded to earlier, sometimes the court says it's assimilating law, but in fact is creating new law. So if this were Sesame Street, this would be one of these things is not like the other, and in fact, the Supreme Court is trying to conform patent law with broader legal norms. All right, so this project has taken a number of different forms. First, the Supreme Court has enforced trans-substantive regulatory schemes like the Federal Rules of Civil Procedure, and we see this in two different cases separated by about 30 years. In Dennison versus Panduit, the Federal Circuit had reviewed the district court's factual findings regarding non-obviousness with little deference, perhaps invoking its own kind of specialized expertise in patent affairs. Upon appeal, the Supreme Court applied Federal Rule of Civil Procedure 52A, which mandates clear error review of district court factual findings. So the Supreme Court says, the Federal Circuit, you're an appellate court, you should review district court factual findings for clear error. We see something similar more recently in Teva versus Sandoz. The Supreme Court rejects the Federal Circuit's practice of reviewing claim construction de novo. Here again, it applies Rule 52A to review factual findings for clear error. So we know that there are certain kind of unique aspects of the Federal Circuit and of claim construction. Nonetheless, the Supreme Court says factual components must be reviewed for clear error. And the Court really kind of articulates its ruling in the terms of assimilation. It says Rule 52A does not make exceptions or purport to exclude certain categories of factual findings from the obligation of a court of appeals to accept a district court's findings unless clearly erroneous. All right, so we see the Supreme Court also enforcing other trans-substantive regulatory schemes, such as the Administrative Procedure Act. We see this in a case called Dickinson versus Zerko. The Federal Circuit reviewed PTO factual findings for clear error rather than the substantial evidence or arbitrary and capricious standards characteristic of the APA. The Supreme Court steps in and actually applies the APA to appellate review of PTO factual findings. And again, assimilation is really the message of the day. The Court recognizes the importance of maintaining a uniform approach to judicial review of administrative action. So we just kind of look at the relationship between an appellate court and an agency, and we have to apply the APA. Now, legislative and quasi-legislative pronouncements are not the only sources of assimilation. So we also see the Supreme Court applying equitable principles. We see this in eBay versus Merck exchange, where the Federal Circuit had developed a doctrine virtually automatically granting injunctions upon a finding of infringement. The Supreme Court rejects this, and it rejects the Federal Circuit's exceptional rule and establishes a 4-factor equitable test to determine injunctive relief. Again, a lot of articulation around the notion of assimilation. The Court says these familiar principles apply with equal force to disputes arising under the Patent Act. Now, this is rather curious, as John Golden and others have pointed out. In fact, this standard was actually somewhat novel. Nonetheless, the Court employs the language of assimilation to actually create new doctrines. So in some ways, this actually departs from traditional equitable frameworks. Nonetheless, it's introduced in the language of assimilation. All right, so we also see the Supreme Court analogizing from unrelated areas of law. We see this in Global Tech versus SEB, which applies a criminal law concept of willful blindness to inform the mental state requirement for induced infringement. So this might seem odd, given that there's no criminal liability for patent infringement. Nonetheless, the Court says this. Given the long history of willful blindness and its wide acceptance in the federal judiciary, we can see no reason why the doctrine should not apply in civil lawsuits for induced patent infringement under the relevant provision. Right? So again, kind of tying patent law to a broader legal fabric, drawing on concepts from criminal law. All right, so in addition, the Court has eliminated special patent rules in favor of ordinary meanings. We see this relatively recently in Octane Fitness versus Icon Health and Fitness, which eliminates the Federal Circuit's rather technical definition of an exceptional case for the purposes of awarding attorney's fees. So setting aside this rather narrow and technical definition, the Supreme Court simply adopts this. It says, an exceptional case is simply one that stands out from others with respect to the substantive strength of a party's litigating position or the unreasonable manner in which the case was litigated. All right, so finally we see this assimilation of patent law and the elimination of presumptions and per se rules at the intersection of patent and antitrust. And we see this in 2 cases. The first is Illinois Tool Works versus Independent Inc., where the Supreme Court eliminates the presumption of market power in antitrust cases involving tying arrangements with patented products. And so doing, it attempts to reconcile patent misuse doctrine and antitrust doctrine. We also see this in FTC versus activists, which eliminates any per se rules regarding reverse payment settlements. So, there's no per se or presumption of legality or illegality. We simply subject these settlements to the rule of reason. And here again, I think we see a consistent effort to eliminate patent exceptionalism and assimilate patent law to broader legal norms. All right, so having gone through a bunch of cases, the piece then moves towards some analysis. So it asks, what's happening here? So what's motivating the Supreme Court to assimilate patent law? And I think that there are a variety of different motivations. So first and probably most obviously, the court is reining in exceptional Federal Circuit doctrine. So in a number of areas, the Federal Circuit's made rather unique doctrine. The Supreme Court is kind of smoothing this out, conforming patent law with broader legal norms. In addition, and in so doing, the Supreme Court is also reining in the Federal Circuit itself. So a lot of this doctrinal exceptionalism is rather self-serving on the part of the Federal Circuit. So with respect to, for instance, less deferential review of district courts and the PTO, the Federal Circuit is actually enhancing its own power. So not only is the Supreme Court kind of tamping down exceptionalism in the doctrine, it's tamping down the Federal Circuit itself. I think we see here the Supreme Court canvassing a wider set of legal and policy interests in the Federal Circuit. So some people have said the Federal Circuit doesn't really care that much about policy, doesn't write a lot about policy and opinions. I think it's pretty clear, though, it does care about certain policies like certainty and predictability in patent law. But I think that the Supreme Court is actually interested in a wider set of policies, such as consistency and coherence in federal law. All right, so I think that we see here a rather interesting institutional irony. The Federal Circuit has unified patent law, and in so doing has created some exceptional doctrine. The Supreme Court has unified patent law on a grander scale, really conforming patent law with other areas of law, and in so doing it's eliminated a lot of this doctrinal exceptionalism. All right, so I think that there are some less charitable motivations behind this development. In some ways, I think the court is relying on familiar legal principles to navigate technical patent issues. So patent law can be rather technical, rather kind of inaccessible to Supreme Court justices. Justice Scalia once said this: at that point, a patent doctrine is much less tied to general principles of law with which I am familiar, and much more related to the peculiarities of patent litigation with which I deal only sporadically. Right? So he's almost professing he may not really understand the technical weeds of patent doctrine that much. In some ways, this trope of assimilation reduces the cognitive burdens of patent adjudication. So you don't actually have to engage the details as much. If there's a trans-substantive rule that can resolve some case, like Federal Rule Procedure 52A, just invoke it. All right, so in addition, I think that there are certain rhetorical indications of assimilation that help legitimize novel doctrine. We see this again in eBay versus Merck exchange. The court actually does create a rather new equitable test, but it cloaks it in this language of assimilation, of historical principles. This can enhance its legitimacy. And in these dynamics, I think we see the ongoing tension between a specialized and generalist court. All right, so moving towards prescriptions, I would suggest that universality is a worthy goal, but some exceptionalism is warranted. And I think in particular, the unique presence of the Federal Circuit justifies some deviation from broad legal norms, perhaps less deferential review of district court and agency factual findings. And I've talked a lot about courts in this talk, but I think there's a role for Congress to actually think about these things and calibrate and perhaps legislate some degree of exceptionalism. In the meantime, I think that there's a role for an intermediate form of universality. So we can have universality, we can have standards that apply across multiple subject matter domains, as long as they're flexible enough for context-specific elaboration. So perhaps one example of this is the rule of reason in antitrust cases. So this is kind of the quintessential standard, like courts can tailor to individual facts. And the equitable standard in eBay comes close, but as I pointed out, there are a few shortfalls to that pronouncement. All right, so let me just sum up here. This piece has explored an underappreciated descriptive theory, Supreme Court patent jurisprudence. It argues that the court has been assimilating patent doctrine to general legal norms and standards. This has taken a myriad of forms. So the court has enforced trans-substantive regulatory regimes. It's invoked traditional equitable principles. It's reasoned by analogy. It's eliminated specialized patent rules in favor of ordinary meanings. And it's eliminated per se rules at the intersection of patents and antitrust. One of the guiding messages is that there's nothing special about patents, or there shouldn't be anything special about patents. The court has engaged in both substantive and rhetorical uses of assimilation. And again, I think this reveals certain tension between the quasi-specialized Federal Circuit and the more generalized Supreme Court. I do think that some selective exceptionalism is warranted. We have a very unique institutional structure in patent law because of the Federal Circuit. I think it might be wise to adopt flexible standards. that allow for context-specific elaboration. So with that all closed, I'd love to hear your questions and comments. Yeah, Mark?
So very interesting. I mean, I think it's got to be right at some substantive level, and the question is, what's causing it?
Right.
And in particular, let me sort of give you kind of two things that sort of parameterize that question. One is the court did mostly, with a couple of exceptions like Dennison, lay off this area for 15 years after the Federal Circuit was created. And there are still substantive areas like ERISA and Admiralty where the court seems perfectly happy to go the exceptionalist route. So it can't be a general Supreme Court project to assimilate everything into a general body of law. I wonder if what changed in part is the nature of the patent practice bar. Right, and in the early 1990s, as we start to leave the all specialty firms and more general practice firms start to get involved, I wonder if that ends up kind of driving the introduction of principles from outside patent law in a way that moves the court.
Yeah, interesting. So I hadn't thought about that. I think it's a great theory. But I think that, I think there is no general project on the part of the Supreme Court to assimilate, but it does become a question of degree. So I think if the court observes a particular court in the Federal Circuit veering really far off the range, perhaps it does want to kind of bring it back home. But it's a great point about the patent law. We'll go into that deeper. Yeah.
It's sort of what I was thinking is patent law has moved into sort of the mainstream of public consciousness, and the Supreme Court follows the public consciousness. And that leads to my question. I don't have an answer for it, but what do you see the 101 cases fitting into this theme as well, or are they in a sort of bucket all by themselves, and that they might be explained in part by this following the public perception of patent law?
Right. So great observation. So two responses there. So one, absolutely right. So I think that patent law has moved from the fringes more to the mainstream. And I think that you see, a greater appreciation for patents in the economy that might motivate the Supreme Court's kind of renewed interest in patent affairs, kind of tamping down patent rights. So one part of the piece which I didn't have time to mention is that, in many ways, this project doesn't really apply to the real substantive technical patent doctrine that we probably write most of our articles about. Right? So 101, 112, claim definiteness, non-obviousness. And really, those areas are kind of unique to patent law. There really is no analogy to non-obviousness in other areas of law. So this project of assimilation can't really relate. So a lot of this assimilation of project relates to remedies, procedure, cross-cutting trans-substantive issues that would impinge on other areas of law. Yeah.
To test the notion of whether or not this is something that's specific to the Federal Circuit, have you looked at other? We can't make this a case about all of Supreme Court law, as Mark mentioned, but what about intellectual property, right? Do you see the same kind of either framing and assert questions about universality, or are the types of questions posed in the cases that come from the circuits different types of questions, when the questions posed are questions that are potentially universalizable? In fact, does the court go in that direction? So it might be interesting to look at the other IP cases as a control, in a sense where there isn't a Federal Circuit specific court, and then maybe that would give you some backing for whether or not this is being for the very plausible theory, on its face, that in fact the Federal Circuit has a lot to do with what's going on.
Yeah, I think it's a great suggestion. So, my intuition, I think, tracks your question, is that this kind of invocation of assimilation probably arises more in other areas of IP. So the Federal Circuit might have more kind of tunnel vision, and so patent cases might invoke these principles a bit less. One other thing to mention kind of in that regard, though, a subset of assimilation is assimilating patent doctrine to other IP doctrine. So I have a little section in the piece dealing with that. That's kind of low-hanging fruit assimilation. I think we see a lot of that in the court as well. So with respect to remedies, we want copyrights and copyright case and patent case to have a similar approach to injunction and so forth. So this project actually expands beyond that and looks beyond IP. But I think it's an interesting project to look at just how assimilated and kind of internally consistent IP is itself. Yeah.
So I don't think this problem is unique in intellectual property. I think that there's other technical areas of law, like let's say securities reg, where stuff like this happens. And so I think to that end, I'd like to recommend this article that I think never gets cited
Okay.
that focuses on this problem. It's by Saul Levmore, and it's called The Theory of Deception. And it goes through different areas of law and talks about, why does it have to be true that this concept of deception is, that we have the same thinking of why deception has to apply the same in the securities context, in the tort context,
Right.
kind of all of that stuff. So, I mean, I think that will go a long way to the prescriptive component about having universal rules that can nonetheless be textured
Right.
for the end of your piece. So, yeah.
Right. Okay, great, thanks. Yes.
So I wonder if you've thought much about how Congress fits in here, because you seem to be speaking mostly in terms of the Supreme Court and the Federal Circuit, but I think one of the arguments that the Supreme Court might make in defending itself is that when Congress comes up with laws that are about substantive patent law, it presumes a universal background.
Right.
And so I was wondering if that might be a fruitful area to explore more how Congress fits in.
Right, so it is. So this piece does focus mainly on the courts, but I think Congress has a very important role to play. And in fact, Congress can legislate exceptionalism. We see this in the AIA with jurisdiction. It's actually overruled an earlier case. And so the general kind of prescriptive push is for more legislative deliberation. So, there are good reasons to have universal rules. There are good reasons in some pockets to have exceptionalist rules, but I think we need more kind of formal, kind of systemic deliberation to really come to the right answer, and in some cases to legislate exceptionalism, because I think the patent system is a bit different.
Building off of that, Congress really drove unifying administrative law. We used to have a million standards of review.
Right.
And so I think, building off of what Will said, I think you have to consider Congress does play a role. Also, I want to mention DC Circuit's quasi-specialized as well, and we still have uniformity in administrative law notwithstanding that. So I think maybe bringing that in a little bit is some earlier commentating.
Yeah, so it's an interesting parallel between the DC Circuit and the Federal Circuit. They're both, quasi-specialized or specialized in some regard, and we do see some deference from the Supreme Court to the DC Circuit in administrative law. And for a long time, we've seen that on the part of the Supreme Court. I think, as I mentioned earlier, maybe the court thinks the Federal Circuit is veered a bit too far from the mainstream and is kind of pulling it back in. But some sort of equilibrium where there is some deference, but yet you're in the broader legal fold, perhaps that's the right balance. Yes?
You didn't mention anything about outside constitutional forces that might be a factor, like on the factual deference issue. The Seventh Amendment is lurking underneath that.
Right.
So in some of the IP cases, I think this is probably more true in the copyright IP area than the patent IP area. The court seems to be pulling the Federal Circuit back into constitutional compliance as much as anything else.
Right, I think that's another important source of assimilation. So it's not just statute, it's not just equity, but it came into the Constitution as well.
But that also affects whether Congress can step in and do something exceptional, because they may not be able to without
Right, exactly.
triggering a constitutional problem.
Exactly, thanks. All right, thank you very much.